International Law and the Ukraine Crisis. My research is focused on the law of war, i.e., jus ad bellum. Can I get a show of hands for anyone who's heard of jus ad bellum before? Okay, that's the interactive part of the presentation over. Before we start, I'd like to highlight two things. One, jus ad bellum is part of public international law, which means the law between states or countries, as opposed to the law between a state and a person, such as criminal law, or the law between persons and other persons, such as contract law. Second point I'd like to make is jus ad bellum is about whether it's lawful or not to go to war. That's important because it's easy to get mixed up between the law of war, jus ad bellum, and law in war, jus in bello. The law of war is when you can go to war. Law in war, or humanitarian law, jus in bello, is about what you can do when you're already fighting a war. So if you invade another country, that could be a breach of jus ad bellum. If you're fighting a war, whether it's lawful or not to go to war, if you use poison gas, exploding bullets, or other prohibited weapons, that's a breach of jus in bello. And today, we're only concerned with the former, when it's lawful to go to war. What is the law of war? The law of war is very simple, and it's contained within Article 2.4 of the UN Charter, which says, don't go to war. Pretty much every country has signed the UN Charter, so it's a pretty big deal. However, don't go to war is a pretty hard thing to write an entire PhD on, even for someone as creative as me. The difficulty is in the application of Article 2.4, especially because we have a number of exceptions to the general rule. Now, we don't have time to go over all the exceptions here, just the ones that apply most obviously to Ukraine. What happened in Ukraine in 2014, Alex? This guy happened. To any Russians in the audience, this is your president. Yes, Russia annexed Crimea in 2014 and is continuing to support armed shenanigans in eastern Ukraine. Now, the trigger for this, bringing it back to where it all started, was the decision of President Yanukovych of Ukraine to suspend plans to ratify a draft treaty between Ukraine and the European Union. One of the purposes of this treaty was to establish conditions for enhanced economic and trade relations, leading eventually towards Ukraine's integration into the EU internal market. Sounds fabulous, doesn't it? Despite Russian objections, the Ukrainian government approved the draft agreement in September 2013. However, in November 2013, the Ukrainian government backed down from signing the agreement. This decision led to widespread protests organised by pro-European opposition parties in Ukraine, and it also led to the occupation of central Kiev, the capital of Ukraine, by protesters. The protests lasted several months. Attempts by the Ukrainian government to calm protesters with the promise of a $15 billion Russian aid package on the 17th of December were unsuccessful. On the 21st of February 2014, 2 months later, protests were still happening. President Yanukovych signed a compromise deal with opposition leaders, facilitated by a Russian special envoy and the European foreign ministers of France, Germany, and Poland. The agreement set out plans to form an interim national unity government within 10 days, followed by wide-ranging constitutional reform and new presidential elections no later than December 2014. However, the deal was never implemented, it was rejected by a majority of protesters in Kiev, who gave Yanukovych an ultimatum to leave the capital or they'll storm government buildings the following day. And that's exactly what they did. Yanukovych, however, had already fled to Russia via Sevastopol, and on the 22nd of February, the Ukrainian parliament voted by 328 votes out of 447 to remove Yanukovych as president. And that's when the Russians come in. Crimea has been part of the territory of Ukraine since the country gained independence after the collapse of the Soviet Union. In former years, it had been part of Russia before Nikita Khrushchev gifted the peninsula to the Ukraine region in 1954. What a generous man. Crimea is populated by a majority of Russian speakers, and within the Ukrainian political system, it held a special status as an autonomous region governed by a local parliament. Crimea is also of particular importance to Russia, both historical and geopolitical. Since 1783, Crimea has been home to the Russian Black Sea Fleet at Sevastopol. Following the departure of Yanukovych, Crimea became engulfed in pro-EU and pro-Russian demonstrations. Russia began sending unmarked troops, that's troops without any insignia, into Crimea, who established checkpoints on the border of the peninsula and occupied key buildings. The Crimean Parliament held an emergency session on the 27th of February and voted to install the pro-Russian faction leader Sergei Aksyonov as Prime Minister, following which the Russian Parliament authorized the use of force in Crimea. Now, the referendum was held on the 16th of March, the result of which was 96.8% in favour of Russian integration. But it might as well have been 290% in favour of Russian integration. Russian integration was going to happen. After the referendum, the Crimean Parliament requested to be admitted to the Russian Federation. On the 17th of March, Russia recognised Crimea as an independent state, and on the 18th of March, Russia concluded a treaty with the independent state of Crimea, formally annexing them. And that, as they say, was the end of that. What does jus ad bellum, the law of war, have to say about all this nonsense? Well, let's remind ourselves of the law of war. Don't go to war. Or to put it in academics' terms, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. Article 2.4 is what we call a peremptory norm, which means if you break the norm, the UN will be very, very angry with you, and they'll probably write you a letter telling you how angry they are. So the only question really is, was what happened in Ukraine a use of force or a threat of force? And that isn't such an easy question, because there are quite a few ways, I'll call them exceptions, although that's a bit of a simplification, but let's just say there are exceptions that can render the use of military troops in another country lawful under public international law. For example, self-defense, contained in Article 51 of the UN Charter. If someone invades your country, you are allowed to fight back. Were the Ukrainians invading Russia? No, so it's not self-defense. There are other exceptions too, some of which the Russians tried to use, but their arguments were pretty rubbish. They had one good argument, and that's that they were invited into the country by President Yanukovych. And fair enough, he did invite them in. That's important because if you invite someone in, how can it be a use of force? Force, by its very definition, requires a lack of consent. Now, this exception is called intervention by invitation. Intervention by invitation is a brilliant topic in international law, but it's also a difficult topic so it tends to be written about only by the most intelligent and physically appealing international lawyers. That's why it's the focus of my PhD thesis. And the way it applies in Ukraine is very simple. If Yanukovych is the president, and he has the power under the Ukrainian constitution to invite troops in, when he does so, it's not a use of force, is it? It might violate other international norms, maybe, but it's not a violation of Article 2.4. The question for us is, was he the president, though, at the time he invited the troops in? Surprisingly, the Russians thought he was. On the 3rd of March, in a UN Security Council debate, the Russian ambassador to the UN produced a letter from Yanukovych inviting outside intervention. The letter read as follows: "As the legitimately elected president of Ukraine, I wish to inform you that events in my country and capital have placed Ukraine on the brink of civil war. Chaos and anarchy reign throughout the country. The lives, security and rights of the people, particularly in the southeast and in Crimea, are under threat. Open acts of terror and violence are being committed under the influence of Western countries. People are being persecuted on the basis of their language and political beliefs. I therefore call on President Vladimir Vladimirovich Putin of Russia to use the armed forces of the Russian Federation to establish legitimacy, peace, law and order, and stability in defense of the people of Ukraine." Yanukovych later confirmed that he had actually indeed requested Russian military assistance following his deposition, although he also said he regretted it. If Yanukovych was the president at the time, then it's likely that the request was valid. A head of state in international law represents a country at an international level and is therefore capable of consenting to military intervention. However, several states denied that Yanukovych was still the president after he left the country. In the 3rd of March Security Council debate, the UK ambassador to the UN said the following: "The Russian representative claims that Mr. Yanukovych has called for Russian military intervention. We are talking about a former leader who abandoned his office, his capital, and his country, whose corrupt governance brought his country to the brink of economic ruin, who suppressed protests against his government, leading to over 80 deaths, and whose own party has abandoned him. The idea that his pronouncements now convey any legitimacy whatsoever is far-fetched and in keeping with the rest of Russia's bogus justification for its actions. The government in Kiev is legitimate and has been overwhelmingly endorsed by the Ukrainian parliament." But if Yanukovych was no longer the president at the time of the invitation, how did this state of affairs come about? He was, after all, elected under a democratic process, and his term had not expired at the time. Well, there are three possibilities. One, Yanukovych could have lost his legal status by virtue of the corruption and potential human rights violations mentioned by the UK ambassador. Two, he fled the country, so maybe that's a reason for him no longer being president. And three, the Ukrainian parliament voted to remove him from office the day after he left. Now, the first possibility, the corruption allegation, that can be dealt with relatively swiftly. There is little evidence to suggest that corruption or human rights violations below the level required of certain international standards can affect the international legal status of a government. Now, corruption and human rights violations might be a political factor in determining whether other governments treat a particular government as the legitimate government of that country, but there's no direct legal effect in international law. Many governments have been accused of corruption and human rights abuses, but this does not affect their status as representatives of their states at an international level. The fact that Yanukovych fled the country is more relevant to the issue of his legal authority. Under the traditional effective control test in international law, the government of a state is determined by who controls the territory of the state. This is based largely on practical considerations, because at the time of the invitation, Yanukovych no longer controlled the state apparatus, or even enjoyed the support of his political party. Under a strict application of the effective control test, he no longer enjoyed the legal status of President of Ukraine. However, the effective control test, as traditionally formulated, has been challenged by an increasing number of exceptions in the practice of states. Interventions in Grenada in 1983, Haiti in 1994, Sierra Leone in 1997, and more recently Yemen in 2015 are all examples where it was argued that a deposed president was capable of consenting to military intervention from exile. The most recent example, Yemen, is discussed by me in more detail in my thesis, and it involves an invitation made in noticeably similar circumstances. Yanukovych may also have lost his legal authority through an internal Ukrainian constitutional mechanism. This is the third possibility. He lost the support of his party and his parliament following his departure. On the 22nd of February 2014, the Parliament of Ukraine voted to remove Yanukovych from office by 328 votes to 0. This was, however, short of the three-quarters majority required by the Ukrainian constitution. Because of this, the vote was technically ineffective to remove Yanukovych under Ukrainian law. This suggests that Yanukovych's legal status remained as it had been under the Ukrainian constitution before the crisis began, i.e., he was still the president. However, the consent Yanukovych gave was not without limits. According to the letter presented by the Russian ambassador, Yanukovych called on Putin to use the armed force of the Russian Federation to establish legitimacy, peace, law, and order, stability. It's not clear how Russian actions in Crimea and eastern Ukraine furthered this goal. Instead, the Russian intervention led to the long-term breaking up of the territorial integrity of Ukraine and widespread civil conflict. Consent to intervention of a specific kind is not a blank check to allow intervention of any kind. It's clear to me that the occupation of territory and the facilitation of an eventual annexation goes beyond the limits of a mandate to establish legitimacy, peace, law, order, stability. Furthermore, according to the commentary of the International Law Commission's draft articles on state responsibility, consent to the stationing of foreign troops for a specific period would not preclude the wrongfulness of the stationing of such troops beyond that period. So in conclusion, for me, the Russian intervention in Ukraine was still a breach of the jus ad bellum. It was still an unlawful use of force contrary to Article 2.4 of the UN Charter. But that's because it went beyond the mandate lawfully given to the Russians by a president who had been forced out of his country by armed revolutionaries. Controversial. How do we deal with breaches of the jus ad bellum? What can be done about Russia? And is international law ever effective at dealing with topless, balding maniacs? Ask me over dinner.